Welcome to this channel. Conflicts of laws is the least tested topic in legal studies due to the rigid perspective consistently held by the National Conference of Bar Examiners that the conflicts of laws is not a standalone subject and shall not be tested by itself. According to this standard, the conflicts of law is tested with other subjects such as civil procedure, family law, decedent's estate, intestacy laws, or corporations. Further, the conflicts of laws are tested rather in a predictable way when it comes to long-arm statutes or borrowing statutes. Let's have a look at a conflict co-tested with civil procedure. Here, the rule of law relies on the Klaxon doctrine, a principle whereby a federal court exercising diversity jurisdiction must apply the choice of law rules of the state where the court sits. For example, if before a federal district court are parties from diverse jurisdictions, namely Maryland and Nebraska, and where the plaintiff is from Maryland and alleges $1 million in punitive damages, under the Klaxon doctrine, the federal judge hearing the case has to follow Maryland's choice of law rules when determining damages, even when Nebraska follows the 50% modified comparative fault system where plaintiffs may not recover if they are found 50% or more at fault. Besides, Nebraska practices constitutional limits on the amount of punitive damages awards, which must not be more than 10 times compensatory damages. On the other hand, Maryland adheres to the contributory fault doctrine, where plaintiffs may not recover if they contributed to the damage in any way. So the federal judge must vet predominantly on Maryland's standing. The interface between contracts and the conflicts of laws are pretty much straightforward. I will let you explore the two corresponding slides on your own. Let's look at the situation in family law. The most tested issue of conflicts is the recognition of marriage. The rule of law is that marriage is valid under the law of the state in which it was contracted, and that legal bond must be valid elsewhere. For example, a couple enters a common law marriage in Kansas, and soon after, the wife moves alone to work and live in Louisiana. While the United States is a common law country, Louisiana is the only state that is based on the French Civil Code as opposed to other states that adopted common law of England as the general law, except when a statute provides otherwise. If the woman's common law marriage was valid in Kansas, will Louisiana recognize it? The answer is no. Louisiana does not recognize common law marriages. In order to have a marriage status in Louisiana, one must legally file for marriage. However, that woman's common law marriage from Kansas will be valid in all other states and the District of Columbia. Another doctrine by which the conflicts of laws are tested is the full faith and credit clause. The law states that a state shall recognize another state's final judgment if the judgment was on the merits and the other state has jurisdiction. For example, if a couple divorces in Montana, all other states may see their divorce as valid. There are limitations indicated in this slide. The next slide depicts the U.S. Supreme Court's attitude for this doctrine. Now about the conflicts of intestacy laws. Basically, there are two rules that govern the post-mortem distribution of a deceased property. Personal property distribution is governed by the state where the deceased was domiciled at the time of death. Real property inheritance is governed by the state where that property is located. For instance, if a person was domiciled in Montana during his death and had a real property in New Hampshire, that property will be distributed according to New Hampshire's laws. By the way, New Hampshire is the only state that recognizes common law marriage only for the purpose of property distribution. What about the intellectual property or e-commerce? The legal forum isn't settled in this regard, and matters of that kind are referred to the postmortem confidentiality or privacy laws, where the deceased client and attorney privilege is the dominating rule. Besides, trademarks, patents, and copyrights are governed by federal statutes, and each law has postmortem extension of publicity. Unlike patents, trademarks, or copyright, trade secrets are not governed by federal laws. As a type of intellectual property, trade secrets are primarily governed under the state laws, and the owners have more limited recourse when their rights are violated. This slide shows the conflicts between Schaeffer and Shavin decisions in terms of attachment or sequestration of things of the defendant who has never been present in the state in which the action against him was filed. International Shoe decision promulgates this rule to achieve effective remedial justice in the federal court system. What about the conflicts of laws concerning the possession of a chattel? The corresponding rules and examples are provided. Let's look at one more field of law that interfaces with conflicts of law: corporations and LLCs. Here, the most tested matter is merger, vertical integration, or horizontal consolidation. Merger of a domestic corporation with a foreign corporation is allowed under the Model Business Corporation Act. So, the law governing legal disputes of a merged corporation will not be reduced to the registered physical address of the corporation or its headquarters. Here, I also discuss the extent of the state power in exposing new rules upon the pre-existing corporations. Further, this slide explains the difference between a corporate merger and no-merger claim rule of law. Examples are provided. Here I show how the borrowing statutes come to solve the problem of discrepancy in statutes of limitations between the states and issues generated thereof. With this brief intro, I try to cover the conflicts of laws tested in certain fields of law. Yet there are still so many uncharted territories where a specific area of law can be scrutinized for conflicting rules. This could be U.S. maritime aviation losses, especially conflicts of the substantive laws, which are applied to cases arising within the Admiralty jurisdiction. Other areas of concern will be the borrowing statutes, antitrust, e-commerce, interstate employees' welfare, advance directives appointing a foreign domicile, human organ and tissue transplantation, abortion tourism, surrogacy tourism, as well as the trafficking of the emancipated teenager, to name a few. The point I am making is that conflicts of laws should not be reduced to a jurisdictional diversity issue. I will produce videos about the conflicts of laws generated by the failures of the judiciary or legislative branches. I will contribute my humble part in making the conflicts of laws a standalone subject, not only between but also within the jurisdictions. See you then.